Here to introduce John James, who is working with Deloitte and Touche and has a great deal of experience in advising law offices and legal technology practice, and is a member of several organizations that do and I've written about it. And so let me turn it over to him.
Good afternoon now, I guess, quarter after. What we're going to do is going to be a lot more informal than I might have originally planned, but let me sort of set the stage for what we're going to talk about. The topic given was communications with clients, and the business that I'm in involves a lot of well, let's put it this way. The parent practice that I'm in is called Forensic and Investigative Services. Now, a lot of people jokingly say that our business is defending the wrongfully accused, but in fact, we are involved in investigations and forensic investigations using technology and delving into technology, hardware and software, for both sides of a number of different type of cases. We're going to talk about this. But the thing that's consistent through all of this is something that I've sort of referred to as electronic DNA, because the similarities between DNA and the footprint, the fingerprint, the signature, whatever you want to call it, that computer hardware and software and you as users leave has become, I guess, omnipresent. You can't get away from it. If you wanted to, you couldn't get away from it. And what implications does that have for you as lawyers when you're communicating either with clients or with opposing counsel or with government regulatory agencies, or even in your own personal life? Because once you go out and become lawyers in a private practice, a government agency, or even a corporate law department, I'll give you an example here later on how even your private life is now integrated with your business life and your practice as a lawyer, and you can see what effect it could have on you. Communicating with clients, whether it be by cell phone, email, formal documents, a will, a contract, a merger and acquisition agreement, you name it, patent prosecution. These are all things that you do in your practice as a lawyer, or you will select maybe one of them to focus on, but the tools that you're going to use to do that now are the cell phone, the PDA, the laptop computer, networks, and a whole host of application-specific software that is more and more designed to tie you as a lawyer directly to your client. We'll talk about some of the aspects of that later on too. The DNA, electronic DNA, I don't know how many know it. Is there a fair level of technological savvy here? I mean, I assume that you get this as part of just going to college nowadays, let alone practice of law as well. But as a quick for instance, when you turn on an IPAC PDA, when you create email on that, you are putting in there in the hidden text area, there's information about who you are, what machine created this. There's hardware signatures that are attached, that are built in, manufactured into every microchip. You use a cell phone. There's a phone number that you're associated with. There's software that will track who you called, where you called from, where the person was that you called. So all of this is kept in systems that are built to track this information. And it just accumulates. Just like we were talking earlier, you know, they've wired me up for sound for this presentation. It's going to go in the archive. Nowadays, virtually everything you do is captured in electronic format. Not everything. I know that, you know, sometimes you can have a private moment, you can go for a walk in the woods. But if you go to the airport today, like I'm going to do, I'm going to travel back to San Francisco, it is estimated that I will be videotaped or captured on video 100 times between now and San Francisco. So somewhere around here on campus you may have security cameras. At the airport, at the parking lot, at the car rental lot, there are cameras, sometimes 3 or 4, and they will be able, if someone wanted to, in the future, they'd be able to go back and say, let's check the video records of this face. Now, granted, that may not be a pretty task, but nevertheless, they could, and more they're getting better at saying, let's search digital video files for patterns. And they could put in my face, I've got a young friend who's just out of college, went to work for Sun Microsystems. I met him on an airplane. I was talking about this video recognition software, and he says, I've got that at my house. He's got 6 people programmed into his home network that when you show up at the front door, the camera there, if it recognizes you, will announce to him over the intercom that John Janes is at the door. So he can elect to shut out the house lights, go to sleep, make like he's not there, whatever he wants to do. But the scary part of this is you're lawyers now, or you will be lawyers when you're out there practicing, and these things, these capture devices, will have more and more of an impact on you and your clients. So the risks that it poses, the video capture isn't a big deal. So you were in court on a certain day, that's fine. You probably won't be looking for alibis very often, I'm hoping, as you go out into the practice of law. But when you do send an email, when you do file a document, when you do prosecute a patent, all of these things, independent of what time you say or you log that you did these things, there will be systems that track when documents were filed. Submitting them now electronically to the courts, it becomes even more intense, because it used to be that there were ways of sort of working the system so that you could get documents at the last minute. Now, if you're sending them in electronically, you have to make sure that they get there, because if they don't get there, their systems at the court will track very intently what time that document arrived. And that, of course, puts you at risk for malpractice, et cetera. Communications with clients, which is sort of the highlight of what we're talking about here, we'll see what impact that can have as you're using these systems to communicate. The typical, let's say that you're in a private practice, for argument's sake. It could be a government agency or even a corporate law department, because they all have clients as well. But you could start out the morning, as I quite often do, going down to breakfast, and I'll be there. I've got a wireless modem on my Palm Pilot or Visor, and I'll sit there and send email or text messages to people that are on the East Coast. And that goes sometimes through my PC at home. Sometimes it just goes straight over the internet to the servers, the service that I have for sending these things. In your case, it might go routed through the server farm at your office. Then it goes out over the internet, where then the reverse happens. It's picked up by the servers at the client network. The client PCs receive the message. Maybe it gets forwarded on to a PDA. And every step of the way, there is more metadata or hidden data that is accumulated with the history of that email or document that says, here's who sent it, here's who edited it, here's where it went, here's when it went, here's where it's backed up. So at a minimum, you'll know who the document creator was, and if it's an email, I'm going to refer to all these things as either records or documents, whether it's an email, a voicemail, a digital picture, or a regular document, Excel spreadsheet, etc. But along the life of this document, it retains who edited it, what edits were done. Now, this is the tricky one. Many of you probably know about revision marking in Microsoft Word. But if you don't turn that off, even if you do turn it off, there's some data that's collected in the header of this document. But if you do turn it off, then there's less chance that people will be able to say, well, what was their thinking prior to this? And a good example of that was a lawyer that I talked to at Skadden Arps many years ago, when this was just beginning to be, I won't say a problem, but an issue, a concern. He worked on a merger of 2 airlines. And he said, in the merger and acquisition business, predominantly, there's a lot of thinking that goes on, notes that are taken, positions that are thought out. So if we went this way, if we put a value on it of X, how would that play out? What would the stock value be? What would the investors get back? And 99% of those notes or thoughts or strategies are eventually discarded. The reason being is, in hindsight, somebody that's not happy with the stock price after the merger could say, I want to know, were there alternatives to this approach? What else were you thinking? So the merger and acquisition lawyers say, we don't want to keep track of that, because anybody in hindsight with the news of the day could say, oh, had you done option 1 instead of option 10, I would have been much better off. But they said, you don't know all those facts way back when you're sketching out option 1. So you don't want to keep a history of that. Consequently, they're very reluctant in M&A work to have revision marks turned on in their documents, because nowadays there's collaborative workrooms, deal rooms as they're called, and both sides to the merger or the agreement can put their documents in that electronic room for the other side to see. Now maybe it's obvious to you, but as recently as a year ago, it didn't seem to be obvious to one of the top M&A lawyers at Wachtell Lipton, who said, well, once we put the document over there, they can't see the revisions on that document. I'm like, au contraire. Yes, they can. All they have to do is bring the document up, say show revisions, and there's the history of your changes and edits and what you were thinking and notes that you posted in the document along the way. So there are, I know now, at least 10 to 20 smoking documents that are out there in deals that someday a plaintiff's lawyer in a share price drop suit will be looking through these documents trying to find out what the lawyer was thinking. Network routers that the document traveled across. When I get an email, I send it from my wireless modem on the Palm Pilot to my home computer. When that email gets there, I can't see it, but if I use the tools that our forensics people have, I could see where this document traveled along the way, which routers on the internet it stopped on in its path to my place. Now, this is important because when you're communicating with your clients, let's say that Walmart, in the news quite a bit, let's say they're one of your clients. You send an email from vacation in the Cayman Islands. You're very successful in the practice and everything else. You got a house down there. You send your email to Walmart, who's your client, and they don't delete this email right away. But more important, it may have gone across or skipped across 2 or 3 servers on the internet along the way, and those servers get backed up periodically by the people that provide that service, that own those servers. So your document exists now on your PDA. It exists on the wireless service host that you use for these electronic emails. It could exist on several servers in between you and Walmart. It exists on the Walmart servers, and it exists on the laptop or the PDA of the person that you sent it to. On the laptop or PDA of the person you sent it to, in that email, it has hidden all the history of which way it got to you, when it was on those servers, who sent it, where it was backed up, a lot of information that can be very useful to lawyers in the future. It can also be very damaging and disturbing to lawyers if you're the person that sent that document and you sent something inappropriate or something you didn't mean to send to that person. So the email metadata, or DNA, consists of all of the information that we've listed up there, plus the post office routing history. And I'll show you later on an example of where that became very important. Metadata or electronic DNA, however, can be minimized. I shouldn't really say cleared. It can be reduced and minimized with the proper precautions if you're doing your job right and using the tools with some risk avoidance. So the areas that this, and I don't know what areas you're going to be specifically focusing on as lawyers, but in estate and tax law, you think about drafting a will for, say, Warren Buffett. And granted, it's probably a very complicated series of trusts, but nevertheless, back and forth through email, because we have this contraption now, you communicate with the client as to what their thinking is. And they very well could say some damning things about relatives, friends, acquaintances, and even other people that they're doing business with. Those things should never go into the light of day. On the other hand, quite often they do. But you can establish a whole history. You can see very easily and very quickly, you can establish a whole history of very damning evidence or information that was never intended to be produced to other people. And there's a history of it now. Even if it's a cell phone call, if you have electronic voicemail at your office and somebody's leaving you a message, more and more people can go back and sort through them and search for certain keywords and names. So it doesn't go away that easily. Patent prosecution and litigation, and there's a very interesting recent case in that where a law firm was both the litigator defending the patent and or defending the non-infringement by their client and the people that prosecuted the patent. So that can have an interesting effect. Employment law and advice. Coincidentally, I don't know whether somebody left this for my benefit, but there's a stack of articles up here. Walmart. The plaintiffs already have won a victory by forcing the chain to disclose so much workforce data. That is, they keep the data, and if you don't have it structured in the right way, protected the right way, quite often you're forced to give this information up to the other side. And like I said before, this data on employees combined with documents, emails that might have gone back and forth between managers, I guarantee you that people can take that out of context and make a case on virtually any aspect of what they want to make a case on. So this history, the communications that you have back and forth between clients, should be assumed that it's always going to be recorded. The patent lawyer. A lawyer, typical patent lawyer, I was just reading this yesterday in IP magazine or something like that. They spend about 2 weeks drafting a patent application and a claim for patent. And they said, you know, they try very much to limit and to make the patent cover everything that it's supposed to. But about 2 weeks of their time. They may do 25, 30 patent applications or prosecutions a year. And then 4 years later, there's litigation over that patent. And some litigator comes back to them and said, what were you thinking when you drafted this? Well, I don't know how good your memories are, and maybe they're honed right now from being in school, but usually 4 years after the event, I can't remember, you know, what clothes I was wearing on a given day, what I was thinking about a given topic. So I might go to my notes or communications that I had a history of with my client. Now, if I have those, and I have them in electronic form, they could end up being discoverable by the other side as well. It depends on how tightly you've protected this. But in a recent court case, law firm that was litigating on behalf of their client, I think it was Merck Pharmaceuticals, but I'm not sure, Merck thought that they had a product that was not infringing on Aon Labs' patent. They got advice from their in-house IP, or from the law firm's IP counsel, who worked for the law firm, and that lawyer gave advice to that law firm's litigator, who then represented it in court. The plaintiff said, well, hold it. We want to know what was going through the mind of the IP counsel. So we're moving to discover or see all of the documents that that IP counsel had when he was saying, he issued a memorandum that it was not an infringing patent. And they said, not only that, we want to know what was in the minds of all the lawyers in that law firm that had anything to do with IP work or litigation of intellectual property. Well, it's a 675 lawyer firm. And by and large, that one little snafu that the IP lawyer had kept all this history of notes and everything else, in addition to the fact that it was the same law firm both litigating and giving IP counsel, opened up the entire law firm to discovery and deposition. Literally, they could have gone and deposed every partner in the firm had they chose to do that. Instead, they'll probably settle, don't you think? I mean, you know, if somebody said to you, you're a law firm, you have something like, I don't know, 2 million documents in your records, and then how many, Lord knows how many million more in electronic form, I want to see all of them. That's a distraction that the law firm probably doesn't need from their day-to-day carrying out of the law. That means they can no longer work for any of their clients. They're busy full-time finding out what they have in their files. So the end point, and you may have seen this before, and you're going to see it several times through this presentation, The main point is you must create a document with the assumption that it will be read by unsolicited and unintended readers. Don't write anything you don't want to read in the Wall Street Journal. Now, as simple as that advice is, and as long as it's been around, every week, virtually, or literally every week, I see another instance of an email that's been brought out that somebody said something that was not only unprofessional, in many instances it's criminally, it's got criminal implications. So I will say this, and I'll say it for the anybody that happens to pick up this tape in a bored moment. When you write either email, a document, a spreadsheet, any application that you use as a lawyer, you have to think and pose your arguments properly, because it's not just a piece of paper and a scratch pad that you can ball up and throw in the trash can that's gone forever. It's not like the thoughts in your mind, which will possibly vanish in a couple seconds. You have to assume that whatever you put into electronic form, either digital camera, electronic documents, or even voicemails, that those things will have the capacity, and more likely will be around for the next 40 to 50 years at least. Yes, Ken?
So how does one frankly but safely among one's colleagues as to things that one does not want later to be discovered? Well,
Attorney privilege, you're relatively protected. However, day by day, that standard for what can be discovered, as I just showed in the case of the law firm, there were communications that they had with other clients that should have clearly been under the attorney-client privilege, but now they were being opened because this other law firm had a need for them. I don't know that there is no safe answer to that question, except when I'm writing down that, and this is not professional, but I've seen these communications. This client is a horse's ass. This client has no better understanding of what they're doing, and I frankly think they'll end up in jail. Those type of things may feed the lawyer's ego as they're writing it, but it won't feed their family, because long term, those comments will be discovered and they will end up defending these late night, sleep deprived, coffee induced thoughts. So all I can say is you have to, as soon as you put fingers to keyboard, and I'll go further on this, eventually it'll even get to your private stuff, and I'll show how a well-intentioned senior associate at a law firm in California lost their job through no real fault of their own, other than they weren't quite thinking what they were doing. It's difficult, if not virtually impossible, to destroy a document once you've emailed it to someone. I think that's obvious. It's difficult to destroy a document once you've put it into your own laptop. We had a case, we got called by a law firm, an IP firm actually, but they were having trouble getting rid of documents because the lawyers had inadvertently, some of them, turned on automatic backup in the word processing software. So even though they were drafting something and then eventually they would delete that, there were several .bak or whatever versions of this document out there. They also had a document management system that they didn't realize that once they deleted it off their hard drive, didn't mean that it went away from the document management system for other people to search through and use as precedent. So I can only reiterate, when you create the document, assume that someone unintended and undesired will be reading that publication, whatever it is that you've just created. And I say this with full knowledge that if something I wrote 15 years ago on a home PC ever shows up, it could have been like a night after a party or something like that. I could have said, who knows what I could have said. And it worries me just a little bit when I go to sleep at night that I know it's still out there somewhere. It just hasn't had a reason to come to light. And these things, I'm not advocating that you lose a lot of sleep over this. I'm just advocating that you consider it in your work. Yes, Melanie?
Are some better than others? If you just wanted to chat with somebody, and is it like a phone better? Does it get less DNA than email?
Yes,
or
currently.
documents?
Currently a phone is less tracked and partly due to government regulation. But let's say you're a Saudi national living here in the United States. If you're on a cell phone, I can assure you that every word you say is captured, analyzed, and if it's got any of the keywords that they're looking for, it will be sent to an analyst to listen to the whole conversation, interpret it, and find out what your intent in that phone call was. This goes back, there's all kinds of rumors and everything about a system called Scepter, I think it is, that the CIA or NSA uses. And it's made the press recently because the European Union has come out, like a little bit angry that this is happening, that they're being monitored and all their communications are being monitored. And the U.S. government says, no, that's silly. Who could possibly create a system to do that? But I actually worked for a computer company in the early 80s who supplied the systems to the NSA. And it's not, classified information. But, what they were looking for was, at that time, they were tracking mostly text messages that were sent overseas, telex, et cetera. But with the advent of good software for text and pattern matching, they can now do voice tracking and capture the words. And automatically, I mean, it's not a human that's listening to your conversation. There's software that listens to it and says, did we pick up, any of these words? And then it routes it on. Yes?
So it's like a prepaid cell phone where they don't know necessarily who has it, they still track it?
They can track it, and that's one, well, no, I wonder. As interested in that, but in the drug trade, that's one of the preferred methods, and now in the terrorism trade, that is one of the preferred methods for retaining some anonymity, but it only lasts very shortly because each one of those discardable cell phones, if it's pulled back, they can track the serial number on it, they can track it back to the manufacturer, who sold it, where it came from. So eventually, the worst case scenario is you go in and you buy your prepaid cell phone in this little coffee shop, but you don't notice that little black eye up in the corner that's videotaping you. So eventually the police get a subpoena, they come in, they say, we'd like to see, this was sold, it looks like on the 12th of February, we'd like to see the video for the 12th of February, and then they can start scanning to find out who the faces are that come in and match that cell phone. So it's only if you've done something really, really horrible that they would go to that extent, but they can. I mean, it's difficult to get away from it. Then, once they got that video, then it's just a matter of saying, okay, now there's 6 other videos out here on the street and at the street corner and everything else, and now we find out where you went and which direction you headed. They can also track where you were when you were talking on that cell phone as well. So they can then track you as a person, even though they may not know who you are at the time. Microsoft emails that talk about destroying the competitors cost the company billions, because if you look at their stock value, the antitrust suits and everything else, these are things that people said, they're a team and they're all pumped up and everything else, we're going to destroy these cretins and everything else. Well, there were a lot of things said in there that were, when taken out of context, and in some instances, when put in proper context, are damning and that should have never been put into email. I can't remember the guy's first name now. I know it well. Maybe it's John Gutman, but he was an analyst, a Wall Street analyst. And what I say down here, if you don't want to read it in the Wall Street Journal, well, I read his emails in the Wall Street Journal because he was an analyst giving opinions for Citigroup on AT&T. Well, the chairman of AT&T sat on the board of Citigroup. And Gutman wanted to get his child into an exclusive private school in New York City. So his chairman, Sandy Weil, said, hey, let's ease up on AT&T, or AT&T Wireless, I forget which one it was, but we need good press on that. And Gutman's quid pro quo was, well, if you can help me get the kid into a private school, because Weil's kids went there as well, then that'd be great. And then Gutman, after it all happened, and his child got into the school, Gutman sent an email to somebody else, says, this is great. We even made $1 million contribution to the school now as part of all this. All of it was then printed and distributed in the Wall Street Journal, and you're thinking, here's a guy that should know better. I mean, somebody had to tell him at one point in his life, hey, emails can be discovered. You know, emails are not all that sacrosanct. So Sun Microsystems, actually the obverse. The DNA, one of our forensics people went in, Scott McNeely was being sued for unlawfully or illegally firing a marketing person or a VP of sales, and they were using email allegedly sent by Scott McNeely as proof that he said, get rid of this person. It was some quote just like that, you know, get rid of him. Because he wasn't going to date that person. That was the alleged, and you know, the reason she wanted to date him, they wanted to continue a relationship, something like that. And don't get me wrong, I'm not saying that Scott McNeely is not capable of that type of behavior, but in this instance, the DNA on the email showed clearly that the originator of that email, a very good forgery inserted into the Sun Microsystems email system, was the person who was suing Scott McNeely. However, it still cost him and the corporation all the time and money to defend that case. And it cost, you know, several $1 million over time to defend that case, even though he was not guilty in that instance. So we've talked about all the things that can get you in trouble. What I'd like to do quickly is just go through, here are the people that are trying to cause that trouble. Yes? Good, and it can be very difficult to break, and that is truly, I guess, the latest best defense against having your information randomly scattered around. However, corporate systems and forensic systems now will also, as you're creating these emails, there are systems that say, I don't want to know what goes onto the hard drive because that's been when it's been encrypted. I want to know what keystrokes this person made, and they log the websites that you visit, the keystrokes that you make, etc. So it's good, encryption can be very good in your client communications, but once the client gets it, it's out of your hands.
Why would company X actually want to keep a record of the keystrokes and websites of their employees on their servers so they come back and bite them in the butt?
It's an odd contradiction or a conundrum, a quandary. The law firm, let's say, or the corporate legal department, they're tracking what employees are doing on the computers that are company property, because other employees will come and say, James was writing this filthy stuff on his computer and visiting porn sites, and I had to see it. So what they do is they say, we're going to monitor real time what people are saying, whether there's inappropriate language in emails, whether there's inappropriate websites that are visited, so that we can stop that. But you're right, the obverse is that you have to then worry about, well, we didn't do anything about it. If you do something about it and you're consistent, you have policies, then you're probably okay. That's going to be your protection. That data that's in there is actually going to be your case that says, you know, I didn't send that to the client. Now I wonder what, I'm trying to think of some of the, Time Warner has a number of record labels that, you know, their lawyers are constantly clearing information and language that goes into the lyrics and the words and movies, etc. So you can't block them from saying, I mean, they have to be able to view this material because it's the material that they're representing, or, you know, the gangster rap lyrics and a number of other record labels have this issue. Quite frankly, I don't know what you do in that instance. UPS, in a similar quirk of the law, UPS tried to take 9, I think it was 9, maybe 19 drivers out of their driver jobs because they had monocular vision. They had they were blind in at least one eye. And no more than one eye, I guess, if it's monocular vision. But they were protected under the Americans with Disabilities Act. So UPS has to now keep track of those drivers and their driving record, and as sure as you and I live or breathe, one of them is going to get, statistically, one of them is going to get in an accident. And the plaintiff's lawyer is going to say, well, they were impaired, their vision was impaired, You knew it, you condoned it, you're guilty of doing this, and you've kept a history of, these drivers as well. But there's nothing they can do about that. I mean, they're forced to track the data, and they're forced to live with the court ruling. So the same thing holds true in a lot of this tracking software. The computer forensics groups are typically the physicists of the organization. They're the people that can talk operating system language. And I was just at a seminar where I was allegedly learning some of this. And the instructor is up here, and he's got a page of gibberish. I mean, it's semicolons, hex symbols, and everything else. And he says, well, as you can clearly see here, when the operating system's booting up, where you have the H9, semicolon, that is a carriage return. So that's where you, like, what? It is totally, it's below machine level language. It's the basic discussions that the computers have amongst each other. But those people are very good at understanding that language. They also know how to come in the middle of the night, start your computer up, and never leave any DNA. They never leave a trace that they were there. And they're experts at copying that data without leaving any changes to that data as well. And there's a number of software tools and everything else that people in law enforcement and the computer forensics industry use to do this. They do it under the authority of the law and everything else. But we just had, just about a year ago, maybe a year and a half, our forensics people who never talk in terms of client names. They'll say the bank, the European bank, whatever. But in this instance, they were talking about, this project we have is pretty neat. We're actually investigating the CEO of a bank. And they said there are changes in the numbers on a spreadsheet that person is the only one that has the authority to change. And yet they're saying they didn't do it, and it's very difficult to see where and when they did it. So they were being let into the office in the middle of the night, standalone computer, not hooked up to a network, and going through the DNA, and they were able to say, yes, it was done by this person. Here's where the metadata indicates the changes that were made and who made them. It was only that person that had access to this room, et cetera. And now, a year and a half later, I see in the papers where there's an executive of a large international bank who's being investigated for illegally giving IPO information or shares to preferred clients. But these folks know the analysis of electronic signatures, DNA. Like I said, they can even go, let's say that you're bright enough to say, well, I know that if I format my hard drive that they can't look at it because that data is all erased. They can go 1, 2, and sometimes in extreme cases 3 or 4 layers of magnetic change down into the disk drive platter and see what was there 3 changes ago. So now if you're very good and you use disk wipe or something like that, there's an NSA standard that if you wipe it that many times, chances are nobody's going to bring that back. But if you've only written over it once or twice, if they want it bad enough, there's a chance that they can still go out and get it. It's better than an even chance. The electronic discovery tools and systems, now there are things like dolphin search and forgetting the animal reference there. These search products don't care what language your document is. It doesn't matter if you've come up with some nifty code, like instead of referring to the President of the United States, you refer to W, or you even put DW as, these systems will go through and say, oh, hold it, no, there's some consistency here. I think I know what that means, and they will come out with a digestion of those documents saying, we think that they were referring to the President of the United States, and here's where, here's who, et cetera. And it doesn't matter, like I said, if you did it all in kanji or in Swedish, it doesn't matter because this software goes through and it applies numeric values to paragraphs. And somehow, don't ask me how, it's patented, but somehow it comes from the numeric value to a semantic intent or value. And they are good at finding individual needles in a whole sea of needles. That's their strong point. Network tracking and sniffer tools. Raytheon has a product called Silent Runner, and it even sounds ominous, but it will start to track, let's say that you're the lawyer for Citigroup, representing Gutman, and at some point you say, oh, this is going poorly. I'm going to start BCCing someone else on the board, everything that I'm sending to him, and that way I'll have my tracks covered and make sure that we're doing all this ethically. Well, these products will start to create visual maps of, oh, and here's when the lawyer started getting scared and copying this person, and here's what that person did with it. So it goes back and you've tried to sort of put out different paths, it will go back and say, let me search out those paths as well. And it's typically undetectable by users or authors, so you don't know that this software is running in the background, it's just there. The litigation management tools, these are the things that you were talking about before. You know, if you have this information, can it come back to bite you as well? There are a number of very good rulings on what can be discovered and what can't. By and large, if you've done everything you need to do to secure the data, if it's representing your case and your client, most of the time that's pretty safe. And these reside in secure web repositories that are only looked at typically by the side that is representing the people in that case. And if you're communicating with those repositories, you're safe, relatively safe, that is privileged and confidential information that's going in there. Work with the idea that what you say, write, and do is being captured, recorded, and stored. I brought this in, it's really not necessary, but digital camera, I've got a portable hard drive that stores 20 gigabytes of information that's about the size of half a pack of cigarettes. These are things where data is stacking up. You know that document that I wrote 15 years ago on a home PC? It's backed up to that drive because every time I change PCs, I take all my personal data and move it over there. So all I'm doing is creating the chain of evidence that will someday be used to get me in trouble for, you know, stealing chewing gum or something. If you take common precautions, when you create a document you're going to send to a client, it's our practice now that we create a PDF version of that, which is basically an image of the document, but it doesn't contain all that metadata. It's not as easily, it is possible, but typically the users at the other side will not know how to modify and edit that document. So what you have is relatively good at representing the final thoughts that you had on that document. Use the firm-provided tools. When you're using your own computer like I do periodically, I could be on a wireless network and I'm exposing everything that's on my computer to the outside world. So if I'm communicating with a client in privileged communications, by going on a wireless network with no security, it may not matter. Somebody sitting next to me at Starbucks could be saying, oh, let me see what he's saying. Yes? The VPN is a virtual private network, is relatively secure, but again, it depends on how it's set up. At Ernst & Young, we had VPNs where you had a secure ID card with it electronically. You're sitting at it, it's a little liquid crystal display. Every minute, it changed an 8-digit number that was on there. So whenever you logged on to the network, you had to enter what was on that at the time you were logging in. And on the server, for everybody that has one of these cards, it has another program running which is putting out the same number at the same time. So it checks that, and then everything is encrypted using that number as one of the parts of the algorithm for encryption. So it's very difficult for people to see what's being said. They can still tell that you're communicating, though. Sometimes that's important, but most of the time, if you're dealing with clients, you just want to know that what you have in that document is secure and it's going to the other side. Every law firm, virtually every law firm on the planet of any size, has a document retention and destruction policy. If they're followed, you're in better position. It doesn't mean that you're guaranteed safe haven, but you're doing the right things. And that counts as much in court as anything else. So when you're dealing with your client, you can say, I did everything by the policy and procedure. That can come to your aid quite often in the judge saying, okay, you didn't destroy that email illegally or because you thought that this was going to be discovered. You did it because it fell under the document destruction guidelines of your firm and it was time for that to go. That's seen in a different light than, oh, we just took everything that was on the hard drive and wiped it out. So understand that the actions you take can affect your practice, group, your firm, and your career. And that brings me to the poor sod that there's software out there that will go to the chat rooms. It's put out by an outfit in Oregon. It will go over the internet and scour for anything you want, any concept, any thought, whatever. So they're showing this software to a law firm, group of partners at a law firm in San Francisco, and they're saying, we can also check the chat rooms. So if you want to see where somebody is saying bad things about your firm in a chat room, we'll show it to you. Now, that's important to somebody like Walmart because they say, we think our lawsuits, product liability lawsuits, actually start in chat rooms under the Walmart Sucks chat site or something like that, where people start to say things and then other people gang on and all of a sudden you've got a movement and a lawsuit. So this law firm says, okay, well, let's see where our law firm name is in the chat room thread and it says Sucks. Well, they come back and they say, do you know Arnold Wong? And they said, yeah. Now the names have been changed here. And they said he's a senior technology associate at the firm here. And they said, well, we've got it. He said something about your firm sucks. So they go and they bring up all the text. And in context, he had been at a dating site. And he said to the person he was trying to date, if you want to see me a picture of me, I know this sucks, but you'd have to go to our firm website and put in my name. So it wasn't really using it inappropriately, but the firm thought it was. They thought we shouldn't be directing our dating partners to the firm website to get information about ourselves. If you want a picture, send them a picture yourself. So, like I said, it's the context that you do all this in, and it's the mindset that even when you're at home at 11 o'clock on a Saturday night going to a date chat site, somebody could end up coming back and saying, what were you doing here? And as long as you got a good reason for it, you're okay. And that is 1 o'clock on the nose, and I think that covers most of what I wanted to say. If anybody has any questions.
Any questions?
Just say, that old saying from Hill Street Blues, the TV cop show, be careful out there.
Is there any litigation out there to tighten this up?
There's litigation on all sides. There's litigation.
Litigation, legislation out there to
Oh.
tighten it up.
No, not that I'm aware of. I mean,
Makes it worse.
yeah, I was going to say, if anything, there are things out there that are constantly eroding whatever privileges you might have had or rights that you might have had. And I think it was Scott McNeely that said about privacy, it's gone, get over it. And I'm not quite sure I'm there yet. I still argue with the cell phone company when they want my social security number for identification. But, it's a losing battle.
We do have pizza and refreshments that were misdelivered to the courtroom, as Melanie noticed, so I invite you to come partake in that, please, before we go on to the next class. And again, Mr. James, thank you very much.